Hello, my name is John Galuzzo. I'm a circuit judge here in Seminole County, Florida. In a few minutes, you'll be appearing before a Seminole County judge by video. If you are watching this on a weekend or holiday, the judge will be here in person. Some of you are here for initial court appearances. The purpose of the initial appearance is to advise you of the charges you have been arrested for and which are holding you here in custody, whether the judge has found probable cause for your arrest, the time, date, and location of your next court appearance, and the name of the judge your case will be assigned to for your mandatory future court appearance. Unless in the future the judge excuses you from appearing here in court, you must appear or your bond conditions may be subject to being revoked. That means you will be rearrested, and often that also means that you will be returned to jail without bond until your case is resolved. Some of you have applied for the Office of the Public Defender to represent you. If you qualify for the Public Defender's representation, you'll be advised of that status here today as well. You will also be given information regarding your bond. Some bonds have conditions, such as no contact with a person or persons, no return to a location, no possession or consumption of alcohol or drugs without a prescription, a requirement that you wear a GPS monitor if it's warranted, proof that the source of funds used to post your bond are not from some illegal activity or other crime, and that is often called a nebia hold. Each crime you have been arrested for requires by statute that you have a separate bond. If you violate a bond condition, it usually will result in your being rearrested and revocation of your bond, which will cause you to be returned to jail to await your trial date or the resolution of your case. It also could possibly be resulting in a new charge for you. Getting arrested for a new crime while out on bond can result in your bond being revoked in your prior case and you remaining in jail until such time as your cases are all resolved. Please be aware that even if you are invited to have contact with a person that you are prohibited from having contact with as a condition of your bond, or that person is asking you to return to a particular location that you're prohibited from returning to on your bond conditions, that if you have any contact with that person or return to that location without prior court approval of your return or contact, even if it is your own home, that you will be rearrested and brought back before a judge to address those issues, and that can violate your bond conditions and require you to remain in jail. At initial appearance, you have several rights. First, you have the right to remain silent. Everything during this proceeding is being recorded, and anything you say can be used against you not only in this proceeding, but any future court proceedings, again, including this one. You have the right to have an attorney present during all proceedings, including this one. This attorney can help you and assist you in these matters, and if you can't afford one, again, upon your request, the Office of the Public Defender can be considered for appointment to you. You have the right to have reasonable contact with your attorney and your family members or friends to assist you with obtaining your release. You have the right to have a copy of your arrest report and to be advised by the judge of what crimes you have been arrested for, as well as, again, your next court date. You'll be given a copy of your court documents after court in any event. Some of you are here for an out-of-county or out-of-state warrant. You'll be advised of your bond status and possibly a review date. However, it is most likely that the bond conditions that are set by the out-of-county or out-of-state judge cannot be changed, and if you cannot post that bond in any event, you will be advised as quickly as possible of when you'll be returned to that county or that state to address those charges. Some of you are here for a 33-day motion. You'll be advised as to whether or not the state attorney has filed an information, which is the formal charging document against you, and if that information has not been filed, you'll be released on your own recognizance. Please be aware that even if you are released on your own recognizance, that you must return for your next scheduled court date. If you fail to appear for that court date, you'll be rearrested and placed back in jail, and you may have to either post bond to get out of jail again, or be put in a position where you'll have to remain in jail subject to the end of your proceedings and the resolution of your case. Either way, we will make sure that you're given a court date to appear that you, again, must appear for. Some of you are here for a criminal misdemeanor arraignment. At arraignment, you enter a plea of guilty, not guilty, or no contest. If you enter a plea of not guilty, you are denying the charges against you, and you cannot be found guilty unless the state can prove the charges against you beyond a reasonable doubt at a jury trial. If you plead not guilty, you'll be set for a pretrial conference approximately 3 to 5 weeks from now. If you plead not guilty, you preserve for yourself the following rights: the right to remain silent, the right to require the state to prove your guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses that may be called to testify against you, the right to call or compel by subpoena witnesses to testify on your own behalf, the presumption of innocence, and the right to have an attorney represent you throughout all stages of the proceedings. If you cannot afford an attorney, again, one can be appointed to represent you. And you certainly have a right to have a jury trial and a right to appeal from any findings by that jury. If you are charged with a misdemeanor and the presiding judge and the state attorney agree that you can enter a plea here today, you may plead guilty or no contest, depending on which one the presiding judge will accept. You may also be sentenced today if you enter that plea. However, if you enter a plea of guilty or no contest, you'll be giving up all the rights that I've just gone over with you by entering that plea. If you're adjudicated guilty of a first-degree misdemeanor, you are subjecting yourself to the following maximum penalties: up to a maximum of 365 days in the Seminole County Jail, a $1,000 fine, or possibly probation for 1 year. If you plead guilty or no contest to a second-degree misdemeanor, the maximum penalty is 60 days in the county jail, a $500 fine, or a possibility of 6 months of probation. Each of those matters will be discussed with you as the case arises, and please remember that probation is not a right. The sentence will be determined by the prosecutor, the judge, and any negotiations your lawyer may have on your behalf. If you are placed on probation, you'll be given certain conditions to perform, and failing to perform those conditions or doing so on a timely basis could cause you to be in violation of your probation, which could subject you to the maximum penalties allowed by law. All felony charges will be given a return date known as an arraignment, and your case will not be resolved here today. We do not take pleas on felonies at initial appearances in Seminole County. As I mentioned earlier, these proceedings will be by video. The law allows a judge to appear by video, but as indicated earlier, on weekends and holidays, most likely the judge will be here in person. Thank you for your cooperation.